Hi everyone, this is video 4 of 4 on pre-termination negotiations, essentially without prejudice conversations aimed at amicably bringing an end to an employment relationship. We've looked at setting the scene, we've looked at matters relating to employee representatives, time to consider, and the admissibility of discussions. We're now going to talk about improper behaviour. So improper behaviour is set out in the ACAS Code of Practice on settlement agreements and in the guidance as well. Essentially, the employer may lose the benefit of without prejudice or confidentiality protection if the manner in which they've conducted those discussions is deemed to amount to improper behaviour. So the ACAS Code on settlement agreements lists some examples of what might be improper, and that unsurprisingly includes all forms of harassment, bullying and intimidation, offensive words, aggressive behaviour. Again, unsurprisingly, physical assault or threats of physical assault, victimisation, any discrimination as part of that process, and importantly, putting undue pressure on a party. So not giving reasonable time to consider, making a threat or an ultimatum such as, if you reject this offer, you will be dismissed, or threatening to undermine the organisation's reputation in the case of the employee if their demands are not met. There is also the supplementary guidance on settlement agreements that ACAS has provided, and that suggests that if we set out our concerns in a neutral manner that have led to the settlement being proposed, that is not going to be improper behaviour. Neither is setting out the alternatives factually, and this is an important point to make. So there is a distinction between saying sign this or you will be dismissed, and if you are not agreeable to these proposals, we will regrettably have to commence a process, be that a redundancy exercise or be that a performance management exercise. That's not a resign or be dismissed ultimatum. That is simply setting out factually what might happen if the employer rejects our proposals. We are entitled to say that if an employer refuses the settlement agreement and they ultimately do leave on other grounds, the likelihood is that the terms of the exit are not going to be as favourable as the offer. We don't have to agree to provide a reference. We don't have to pay for the employee's independent advice, although in both of those circumstances that is fairly usual. We are entitled to ask the employee to reconsider any refusal of those settlement terms. Now, what we said in the previous video was that aside from the fact that improper behaviour is likely to mean that we lose the protection of those discussions being confidential, in any future proceedings, it is also then potentially evidence that we've treated the employee so unfairly that they actually succeed with their claim. So whether or not we have the benefit of these discussions being confidential, we need to be demonstrating to a tribunal in any future proceedings that we have acted as fairly and reasonably as possible and have not conducted ourselves in any way which amounts to improper behaviour. So I just wanted to finish off on this with two case examples. The first one where the tribunal judged that the employer had acted improperly and the following reasons applied. So no choices were given to the employee. So the employee was effectively told at the outset of the discussion that their employment was over, and this was a discussion around setting the terms of that exit, so what the employer was prepared to give. Well, that's not a choice for the employee to make as to whether to sign that agreement or not, because they're already going at that point. They were put under undue pressure, so I think they were given 24 hours to consider and accept the proposal, and there was no desire to negotiate. So the tribunal said, well, there is the employer has acted with unambiguous impropriety in these circumstances. They'd already made the decision to dismiss, so they were just trying to rubber stamp that by forcing the employee's signature on a document, essentially, to get them to sign. That's not a pre-termination negotiation, that is an ultimatum, and that is essentially acting after the event once an employee has been told that he's going. Now contrast that with another case in the Employment Appeals Tribunal, where they determined that the employer had not acted improperly and had not applied undue pressure. So they told the employee when making the offer that if he didn't accept, a redundancy process would begin. So essentially a consultation process would ensue and the employee would be taken through that process. That's not an ultimatum. They were not told that they were going to be dismissed. The employee was invited to a meeting to discuss the return to work after sickness. And the employer used that meeting, which is fairly common, to be honest, to also introduce the possibility of an offer to leave the business. There was an attempt at a welfare discussion, and that did lead into a settlement discussion. The tribunal considered other factors, such as how that offer was then conveyed and how the meeting was conducted once it became clear this was about settlement, and they agreed that the employer had done everything reasonable and not to put any pressure on the employee to accept that. And interestingly, in this case, and something we went back to in the second video, they set a 48-hour deadline for acceptance. That was for verbal acceptance, following which the offer would be put in writing in the form of a settlement agreement for the employee to agree to. And I think that's a tactic that many employers use, that they will have the discussion and they'll want an answer in principle from the employee within a relatively short period of time. So this is, are you prepared to go on these general terms, financially, and possibly provision of a reference, discussion around post-termination restrictions? The tribunal seems to be willing to allow a shorter timescale than 10 days, as is recommended in the code, for that acceptance to be given. And then a written document, the settlement agreement, will be put in place, and the employer would have a longer period of time, hopefully, to agree to that. So we've covered off in 4 videos the setting the scene, so the framework for having a discussion of this nature, the timescale for allowing the employee to consider whether representation should be allowed, how the admissibility rules work, and examples of improper behaviour which might threaten the admissibility or otherwise of those discussions. If you do need any support on discussions such as this or anything in relation to employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.